Applying the law in real life, where supervision meets daily practice. As we continue building on the previous sections, we now move into practical legal scenarios that brokers and agents face in real-world transactions. This section is designed to reinforce how supervision, licensing laws, and statutory compliance all come together in everyday decision-making. Each question below is rooted in Arizona law and highlights how a broker's responsibility extends beyond policy. It extends into action. Selling mobile homes on leased land. Understanding property type differences. A common question in Arizona real estate is whether a licensed agent can sell a mobile or manufactured home located in a mobile home park where the land is leased. Answer: yes. Arizona law allows real estate agents to sell manufactured and mobile homes located in mobile home parks, even when the home is not affixed to the land. These homes are typically considered personal property, with ownership transferred through a title issued by the Motor Vehicle Division rather than a deed. This law, implemented through legislative updates, reflects how the industry continues to evolve to meet consumer needs. This ties back to earlier sections on classification of property. Understanding whether something is real or personal property directly impacts how it is transferred and regulated. Judgment reporting. A broker's duty does not stop at the transaction. A property manager receives a judgment related to a real estate transaction and wonders if it must be reported. Answer: yes. Under AAC R4-28301, any judgment involving a real estate transaction must be reported to the Arizona Department of Real Estate within 10 days. This reinforces a key supervisory concept. Compliance is ongoing, not just transactional. Brokers must ensure that agents understand their reporting obligations at all times. Branch office licensing. What defines maintaining an office? A broker occasionally rents a conference room to meet clients in another city. Answer: probably not a branch office. Under ARS, paragraph 32-2127, a branch office license is required only when a broker maintains a place of business. Occasional or temporary use does not typically meet this threshold. This connects directly to broker supervision. Understanding operational definitions prevents unnecessary licensing violations. Listing and renting mobile homes. Expanded opportunities with compliance. Can an agent list a mobile home for sale or rent in a park setting? Answer: yes, with proper approvals. Agents may list mobile homes for sale or rent, but must comply with park requirements, including approval of prospective buyers or tenants. This highlights a broader principle. Even when permitted, transactions often involve layered approvals and regulatory considerations. Disclosure of felony convictions. Character matters in licensing. Is a licensee required to disclose a felony guilty plea to ADRA? Answer: yes. Under ARS, paragraph 32-2153, and AAC R4-28301, licensees must report felony convictions, judgments, or adverse actions within 10 days. This connects directly to earlier discussions on grounds for discipline. Licensing is not just about knowledge, it is about character and trustworthiness. Compensation rules. Always through the broker. Can a licensed agent pay another licensed agent directly? Answer: no. Under ARS, paragraph 32-2155, all compensation for licensed activity must flow through the employing broker. This is one of the most important rules in Arizona real estate and ties directly back to supervision. The broker is the central hub for all licensed activity and compensation. Unlicensed activity: who can be paid? Can a non-licensed CPA be paid for services related to a transaction? Answer: yes, but only for services that do not require a real estate license. Under ARS, paragraph 32-2165, unlicensed individuals cannot perform or be compensated for licensed real estate activities. This reinforces a critical compliance point. Understanding the boundary between licensed and unlicensed activity is essential to avoiding violations. Processing fees, a violation of duty and potential federal law. Can a listing agent require a fee to present an offer? Answer: no. A listing agent must present all offers promptly and cannot condition submission on payment of a fee. This may also violate RESPA, reinforcing that state and federal laws often overlap in real estate compliance. Presenting all offers, a non-negotiable duty. Can a seller instruct a listing agent to refuse offers from a specific agent? Answer: generally no. The listing agent must present all offers unless otherwise agreed in writing or prohibited by law. This ties directly to fiduciary duty. The agent's role is to present opportunities, not filter them based on preference. Quick knowledge check. reinforcing key concepts. Fill in the blank. A judgment involving a real estate transaction must be reported within 10 days. Fill in the blank. The disciplinary actions disclosure is required to determine eligibility to hold a real estate license. How this section connects forward. This section reinforces everything we have covered so far: supervision, compensation, disclosure, and compliance. These are not abstract concepts. They are daily decisions that agents and brokers must make correctly. As we move forward, keep this in mind. Every legal question you encounter is an opportunity to apply your knowledge and protect your license. Online discussion. Question 1. Why is it important that all compensation flows through the broker? Answer. Because it ensures proper supervision, compliance with Arizona law, and accountability for all licensed activity. Question 2. What is the risk of failing to report a judgment or felony to ADRI? Answer. It can result in disciplinary action, including suspension or revocation of a license. Question 3. Why must agents understand the difference between licensed and unlicensed activity? Answer. Because paying or allowing unlicensed individuals to perform licensed acts can result in serious legal violations and penalties.